Okay, welcome everyone, and thank you for joining us today for our webinar. Within the broader topic of inclusive investor relations, today we will specifically be focusing on how to prepare for the European Accessibility Act and in turn how to elevate your approach to ESG. I'm Nick Shivkovsky. I'll be guiding us through today's session. Before we dive in, just a few housekeeping notes to bear in mind. This webinar is being recorded and closed captions are available. You can turn them on via the Zoom toolbar at the bottom of your Zoom interface. We'll have time for questions at the end of the session, but feel free to submit them at any point through the Q&A box. We're excited to be joined by John Avila from Level Access, who is an expert on all things digital accessibility. John, thank you for joining us.
Thank you, Nick, and hi everyone. I'm glad you could join us today with tomorrow being Global Accessibility Awareness Day. It's great to have everyone here. Level Access empowers companies to build and create inclusive digital experiences. And we do that through our 25 years of experience with our integrated platform and a deep bench of accessibility experts. Several areas that we focus in, including auditing and testing, building and fixing, and providing dashboards and governance reports to help you monitor and make progress on accessibility.
Wonderful. Thanks, John. I'm going to put a poll on the page for everyone to get things started. So the question for the poll is, how familiar are you with the European Accessibility Act? You should get a prompt on your screen to vote accordingly. And for those that are watching on demand, you won't be able to see, but the results are still coming in. Okay, so we've got a bit of a spread here between some who haven't heard of it at all, some who have heard of it. So I think this session is going to be very instructive for all of you in the audience, and we're going to run you through really the crux of what the European Accessibility Act is all about. So thank you all for submitting your votes. In terms of what we're going to be covering today, we will start with a clear overview of the European Accessibility Act, what it is, who it impacts. We will also discuss the implications for IR teams, especially as it relates to ESG. We will talk through the actions that can be taken now to prepare for the European Accessibility Act with insights and real-world examples. And finally, we'll open the floor to your questions. So, John, to start us off, can you give us an overview of what the EAA is?
Yes, absolutely. So the European Accessibility Act was adopted in 2019 with accessibility requirements for consumers in the EU. Basically, it's a consumer protection act that's meant to harmonize accessibility requirements across the EU and make sure that people with disabilities can access modern technology, products, and services. Previously, there were several countries in the EU that had accessibility laws, but there were other ones that did not. And so this is really aimed at harmonizing a sort of minimum standard for accessibility. This is really important because 1 in 4 adults in the EU have a disability, and access to everyday technology is really critical to make sure that we can take advantage of the skills and abilities that all people have in contributing to society. Each country that's part of the EU was required to transpose the law into their own national laws, and that has occurred. And now the enforcement date for compliance is coming up very quickly. That'll be June 28th of this year. So June 28, 2025 is the compliance date when consumer-facing products and services need to be accessible. Some of the services and products that are covered include things like e-commerce, finance, investment, banking, transportation, etc. And the types of services would include things like websites, investor relation websites, documents, emails, other technology as well, such as kiosks, point of sale systems, and so forth. So it is very comprehensive in the terms of the services and products, and as well as the technology that it is covered. I would also point out that third-party content that's embedded in those services and products are also covered. So it's really important point there. The European Accessibility Act essentially has functional requirements around accessibility. And by and large part, those map really well to the harmonized European standard. It's EN 301-549. That harmonized European standard is already used in Europe in public procurement. And that standard builds on the Web Content Accessibility Guidelines, WCAG, WCAG, version 2.1. And then it adds some additional requirements. So I basically call it WCAG Plus. So if you think about those functional requirements, they're really aimed at the core principles of the Web Content Accessibility Guidelines. And those are perceivable. Can someone with different abilities perceive information? For example, can you perceive it without vision, or with limited vision, or without hearing? Can you operate something in different modalities? Do you have enough time to operate it? Can you use the keyboard if you can't use the mouse or a pointing device? Can you understand the information you're reading? Is the information clear, descriptive? Are there error messages to help you? And then robust, that's the last part. Robust, does it actually work with the technology that people with disabilities use, such as assistive technology like screen readers and the browsers and platforms that we use today.
Great. Thanks, John. That's a really helpful starting point. I think there's plenty to unpick there, but perhaps just widening the lens for a minute. We've seen wide-ranging and large impacts on companies in North America from the ADA, the North American equivalent to the European Accessibility Act. How is the EAA different from other accessibility laws, in your opinion, like the ADA? What can we distinguish between the two?
Right, so the ADA, it's the Americans with Disabilities Act. It applies to both physical and digital experiences. However, there aren't, by and large part, technical requirements around the digital experiences. There's several different sections of the ADA. The one that's probably most relevant here is Title III, which applies to places of public accommodations, including investment relations websites. But again, it doesn't have technical standards. The ADA has been in place since 1990, so almost 35 years. But without those technical standards in place, most things around the ADA end up in private litigation. Sometimes there's enforcement from the US Department of Justice as well, but oftentimes it's through private litigation. With the European Accessibility Act, slightly different, but similar, focused on consumer products and services, and making sure those are accessible. The enforcement date, as I mentioned, is coming up June 2025, right around the corner. And enforcement will be at the national level because each country had to transpose the law to their own national laws. The countries have done that, and then their own internal authorities, so we would call them a monitoring and surveillance authority in each country. Those authorities would take complaints and be a part of the enforcement mechanism. And then depending on the country's specific laws, there would be different penalties and fines and so forth. By and large part, the European Accessibility Act applies to consumer-facing products and services. However, I'd mention for many folks, if you're B2B, or if you sell to a business and then those business then uses your software with consumers, it means there certainly is an impact for for B2B business as well. So even if compliance may not be directly required, there may be a business need to be compliant, or there may be some shared obligation, depending on who the economic provider is, to make sure that your things, your digital things, are accessible. So really, accessibility is a best practice. It can help reduce compliance risk, and also position your organization for long-term success in the EU.
Great, thanks, John. I just for a moment wanted to dive a little deeper into the regional enforcement that will exist across European nation states. Could we maybe explore some examples for specific countries and how they've started to implement their own versions of the EAA?
Right. So prior to the European Accessibility Act, there were several countries that had their own accessibility laws. And some of these laws would apply to private companies as well as public. Some of them apply to employee-facing content in addition to consumer-facing content. So there was quite a bit of those. And these laws may be in effect today. And so it's good to be aware of those laws. And then there's also the implementation of the European Accessibility Act. So some of the early countries that had accessibility laws include France with RGAA. They include Italy with the Stanca Act, Spain. Germany had many laws around public procurement as well, making sure that anything used in public procurement was accessible to people with disabilities, including their own test procedures. I think by and large part, what we're finding is that in the implementation of the European Accessibility Act, most of the countries who updated their laws, the laws are pretty standard across the countries. So there's not a lot of differences in the implementation of the Accessibility Act, but the primary differences are in enforcement procedures. Who is enforcing, who is taking those complaints, the penalties, and those types of things are going to be different. So think about the EAA essentially broadening, expanding compliance around consumer protections in the EU. In terms of some of the penalties and fines, the fines can vary from tens of thousands of euros to hundreds of thousands and even 2 million euros, depending on the country. There can be damages in some countries that can be awarded to people with disabilities if a company was found in non-compliance. And there's also the threat of potentially not being able to do business in a country if accessibility is lacking. Now, I understand that the compliance date hasn't happened yet, but we are getting close to that. And so it's really important to think about how you can prioritize and maximize your efforts to make sure that you can put yourself on the right track to be able to address any complaints that may come along and have those records and so forth to support your ongoing efforts for accessibility and show your commitment to accessibility.
Great, thanks, John. That's a very, very good point. I think maybe to switch topics for just a moment, I think we've talked quite broadly about the EAA and how countries are going to bring this into force individually. And I think given your comments around the uniformity of impact and assessment around the digital footprint from a communication standpoint, I'd like to just link this back to the investor relations use case for a second. I suppose these regulations matter given the digital footprints that IR teams have built over the years, whether that's investor websites or IR pages on corporate websites, investor event webcasts, that could be for earnings or results calls, capital markets days. These types of digital communications obviously fall under the scope of the law. And I think obviously there's a compliance piece to that, but I think what we're also starting to see from our clients and partners is about how to think about ensuring inclusive engagement with all stakeholders ahead of this enforcement date at the end of June. So there's the compliance piece, but there's also a best practice component here. And I think maybe this leads nicely into our next section. But just before we do, so I don't forget, just a quick reminder to anyone on the webcast to please send any questions that you have through in the Q&A box at the bottom of your Zoom interface. We will address them all at the end of the session accordingly. So I think continuing on, John, the question I have for you is, how have you seen accessibility initiatives directly enhance ESG credibility for IR teams?
Yes, so accessibility isn't just a technical requirement, it's also a regulatory and reputational issue to be considered. So the S in social really often can lack tangible actions, but digital accessibility is really putting the S in social in action, showing the commitment to inclusion of a diverse group of people with disabilities that has a need for access. And when we think about accessibility, when I talk to people, they often think, well, my website's maybe not fully accessible, but it's probably usable. I think what people don't sometimes realize is the barriers to access. So accessibility isn't just usability. It's not just maybe a pain or difficult. Sometimes accessibility is really a barrier to people with disabilities not having access to that. So really, I think that's what we're talking about here with the social, is removing those barriers to access, making sure there's fair and equal access to information for that group of people. And if there's inaction, that can create risk. Some of those fines and penalties that I talked about, losing that investor trust. And increasingly, what we're seeing is that globally, accessibility is really important for regulators. It's also important for businesses. And we're seeing it as a competitive advantage. So we're increasingly seeing accessibility being prioritized as part of ESG efforts. More specifically, under the European Accessibility Act, some of those things from an investor relations officer perspective, you would certainly want to be able to report on the digital accessibility efforts, keep records, those types of things. You want to make sure that you're monitoring for accessibility, that the team is trained on accessibility, and that you have some sort of public documentation like an accessibility statement to communicate the efforts that you're taking, the standards you're following. This statement is really aimed at the public and also provides a good place for them to provide feedback. The details in that accessibility statement will be needed to make sure that you're in compliance. These would generally be for investor-facing digital content, including things like earning reports, financial disclosures, shareholder communication, whether it be email or audio recordings. Those types of things will need to be considered for accessibility. And then finally, that accessibility statement, I just want to highlight a few areas in there. The statement, you are required to describe the particular service, also information about the accessibility features that you've used, the technical standards that you're following. So it goes back to that harmonized European standard, EN 301549, which is like WCAG Plus, following those standards to make sure that you're conforming. And then also making sure that you continue to build and procure things that are accessible. Really being proactive is really, really important because you don't want to get in a situation where you get a complaint and you need to address accessibility after the fact, and then you're on someone else's timeline and not your timeline. So really recapping this, ESG is really about emphasizing transparency and inclusivity, and so it really fits nicely with the EAA. And so we would strongly recommend being proactive in accessibility, ensuring that you are compliant, and creating a commitment to accessibility And that commitment to accessibility will also align well with your ESG goals.
Yeah, indeed. Thanks for that, John. And I actually wanted to get your take on a question we're getting asked more frequently, which is on the applicability to UK companies and investor relations teams in the UK and whether they need to take action accordingly. Could you share your general thoughts on this about what is important for the UK IRO scene to bear in mind as relates to the EAA and what is transposed into the UK specifically?
Yep, that's a good question. So well, the EAA wouldn't apply directly to UK consumers because the UK is no longer in the EU, and so the EAA doesn't apply to consumers in the UK. However, the EAA applies to consumers in Europe, in the EU, regardless of where the business is based. So if it's a UK-based business, if it's a North America-based business, you still have to abide by the EAA for covered products and services. So really just highlight the need to be following the EAA is still there. They're all regarding investment. If you're, for example, dual listed in Europe, if you're publicly, traded, any investment sites that have consumers in Europe would be covered. And so just to really highlight that need for investment related information. As well, globally, we're seeing more and more accessibility standards and requirements. There's other ESG requirements in Europe that are coming on this year and next year that companies need to do in terms of reporting on their efforts around inclusion of people with disabilities, and making sure their materials, disclosures are accessible, and so forth. And then globally, we're just seeing the larger expectation from investors, from asset managers, and so forth, making sure that things are accessible. So we have accessibility laws in India and Australia and Canada. And so this really is a global initiative, and following these standards and best practices that we've talked about today will help you be prepared to meet the global requirements. More specifically in the UK, there are accessibility laws like the Equality Act that do require things be accessible to people with disabilities. There's also public sector bodies requirements around mobile and websites for public sector bodies. So there are plenty of accessibility laws and regulations that may also apply in other situations.
Got it. Thanks, John. I think from what you've shared then, it sounds like really teams globally would need to check their connections from their business into the EU to make sure that they are compliant to the extent that's required, but also I think your comments about investors wanting to seek out companies doing the right things, I think that could almost be viewed as a competitive advantage for issuers following the correct standards and conformance to these practices. Maybe just switching topic here. I think given that we've now covered what the EAA is and who is in scope and who this might impact, perhaps could you give some further guidance on the deadlines to be mindful of and why these are so important for teams that need to bear this in mind?
Yes, absolutely. So to reiterate, the deadline for services used by consumers in Europe under the Act is June 28, 2025. So just over a month away. And that is the timeline. After that timeline, someone could submit a complaint to one of those authorities in a particular country. That authority could request records, could do mediation, it could work with you as an organization. And so you want to be prepared as much as you can to be able to make sure that you have that accessibility statement if you're taking those steps, or if you haven't taken the steps yet, that you're working to get those addressed. The penalties and fines, really an inability to do business, et cetera, could be levied. We hear from some countries that I think initially they may be more helpful in trying to say, we'll give you some more flexibility, but you do need to commit to a timeline to address these issues. Other countries, they may be more strict in the enforcement. The law was passed in 2019. It's 2025. It's been 6 years. And so some people will say, organizations have had the time, they've been on notice. And so now the compliance date's in effect. And so some may be more strict. Other ones may try to use reputational damage and really highlight the problems. So it'll just depend on the country and region. So I think it's really important to understand like what regions are most important to you, which countries, and sort of understand those laws to assess your risk and your next steps. So I think the one part that we really haven't talked a lot about is that third party component, and that's really the procurement. When you're using a third party, you want to make sure that the materials and the digital content is conforming, and so you want to make sure as part of those efforts of developing those investor relation materials and sites that you're working with someone like Q4 that's partnered with an accessibility expert like Level Access to make sure that things are designed in a way to be accessible, they're built accessible, and that audits can be done to test against the standards to make sure that you have the documentation and the records to show your efforts and that what you're creating is accessible. And this is really important because, as I mentioned earlier, there's over 100 million people in the EU with disabilities. That's 1 in 4 adults. 21% of the population in Europe is over age of 65. And so we find alignment between the needs of people with disabilities, and as people age, the accessibility requirements are very correlated. And as you live longer, your chances of acquiring a disability increase. So this is just a increasing need worldwide. 1 in 6 people, about 1.3 billion people worldwide, have a disability. So this will really open up your opportunities by creating accessible content and not treating this just like a compliance issue, but also an inclusion issue.
Thanks, Sean. I mean, given the deadline at the end of June, just circling back to that momentarily, that leaves companies with roughly 6 weeks left to prepare accordingly if they haven't done so already. If companies haven't started looking at this in sufficient detail, are there any specific pieces that you would encourage IR teams or indeed other teams that these accessibility laws impact? What should they prioritize on a tight time schedule if required?
Right. Yeah. So if you're working with a third-party vendor, it's a good opportunity to get in contact with the vendor, or to find one like Q4 where there is accessibility. So you want to make sure you have those conversations. You want to make sure you're starting to inventory and understand what are the covered aspects. So making sure what parts of your site and your investor experience are covered under the law, to make sure you can prioritize those. Typically, you want to get an audit kicked off to make sure that you're testing the appropriate things and you understand your baseline. When I talk to a lot of people, they think that maybe they're more accessible than they are. And so when we do an audit, we often find that there's actually more issues sometimes, unless they're working with a reputable company to create their site, that there could be issues. And so then you know where you are, you can start prioritizing those, start the internal training with the teams, start monitoring your site on a regular basis with automated tools through our Level Access platform, for example. And that way you're at least tracking, you're putting those things in process, and you'll be able to tell a better story if there is a complaint, because you actually have started on it rather than being caught off guard and not being able to show your efforts.
Yeah, indeed. Thanks, John. Some very useful guidance there. To wrap up before we move into Q&A, I think it's probably mindful to mention a few key takeaways to bear in mind. Firstly, we've said this a few times, but the European Accessibility Act is approaching quickly, 6 years in the making, and now a month away from the actual compliance enforcement date. So achieving compliance now is pretty crucial, and also helps position your organization as a leader from an accessibility and an ESG perspective. I think also clear that through this conversation, it's accessibility is a tangible and measurable way to demonstrate ESG in action. I think, John, to your points around remediation, that could certainly bog down teams having to answer to relevant competent authorities. So really, taking proactive steps now to stay ahead of issues rather than risk falling behind and sucking up time in remediation. And then I think lastly, this is an opportunity to stand out through inclusion and not just a box to check from a compliance standpoint. So with that, we'll open it up for questions. Please post yours in the Zoom Q&A if you haven't done so already. We will try and get to as many questions as we can. Okay, going to the first few that we have here. John, I think I'll give this one over to you. Are there any tools, in your opinion, that are useful for evaluating your investor relations site current accessibility credentials?
Yes, so it's important to, again, look at what the covered things might be, whether they're documents or audio recordings, players, what type of emails, other correspondence, communication is there. And then based on that, there are automated and manual tools that can be used to evaluate for accessibility. So that could be running a scan that automatically detects issues, things like contrast and missing names on buttons and links, missing captions and so forth. So you can detect those issues. And then automated testing, though, does not address all of the testing needs. Though in addition, you'll probably need to work with someone to do some manual testing as well to make sure things are usable with keyboard and so forth. So it's really a combination of using the automated tools and manual tools, and then also make sure you have the right tools to build things that are accessible from the start. So whenever you're adding content, to make sure you have those tools and those processes in place so you don't introduce accessibility issues.
Got it. Thanks, John. That's very helpful response there. Another question we have through is, how do you measure accessibility progress in investor relations? Perhaps I'll take that one first, and then John, I'll hand that over to you if you've got any further comments. So I think, as we've discussed, accessibility in the sense of the EAA is really impactful from an investor relations standpoint in the context of IR's digital communications footprint. So we've spoken about the investor website and some of the steps required to ensure that that is accessible to your wider audience. I think another point to bear in mind as relates to the digital comms profile for IR teams is obviously when they are communicating with their investors and broader stakeholder groups via investor events like results calls or capital markets days. And I think the need with those to ensure accessibility for all parties is something that I think is relatively nascent, but I think will come into focus in a lot more detail. So I think measuring accessibility progress across investor relations is a combination of those pieces, and indeed other digital footprints that IR teams might have. Social media is becoming a much more popular and more widely used resource for investor relations to interface with their investors. That would be another key concern for investor relations teams. So I think, in short, my view on measuring the accessibility progress for investor relations team is thinking about all of those different properties and really trying to give access to as broad a community as you possibly can, not just to tick the compliance box, which will be required, but also just from a best practice component, and to ensure that you broadcast your message to the widest audience that you possibly can. John, did you have anything you'd like to add on top of that?
Yes, I'd add a few things. Our integrated platform can track your accessibility health over time. And so I think that's really important to show your progress as you fix issues. Not all issues are the same. Some are more critical than others. And so our platform can help you track those critical versus low priority issues. Also track your score over time so you can see the progress that's being made, really to show the return on investment, and to show the progress you're making to address issues. And also it's a great system of record to show what's being monitored, what's being tested. And I think, when I look at progress and process, I'm really thinking about the maturity of accessibility. So initially, most folks are at a very immature level in terms of accessibility, where the processes aren't defined. They really haven't put together the tooling and the training and all of those things that are needed, and they're not taking the feedback and incorporating it. And so I would recommend working with someone like Level Access in Q4, because we can help put those processes in place, assess where you are, and sort of mature the team over time to make sure that you are being proactive, keeping those records, and then improving on your score and your efforts, so that the new it won't be like how long it takes you to fix issues. It'll be how many less issues have we created, and how is our experience more usable to a wider audience.
Great. Thanks, John. And thank you to our audience for submitting these questions through. I think we've got a few more that we can address. John, another question that's come through, I think this one is probably best started on your side. I think it's following on from a comment you made briefly about the penalties that could be incurred from non-compliance. And the question is, what is the cost of inaction in real financial terms? I think that's inaction around the EAA coming into enforcement in June.
Right. Yeah. It's really the penalties and fines can be either tens of thousands, hundreds of thousands, or even €1 million, depending on the country, because each country has their own national transposition of the law. They have their own monitoring and surveillance authorities. It very much will be on a country by country basis. Some countries can also potentially allow for damages. Some could prevent an organization from operating in the country. So they are substantial and real penalties that are in law that could be levied. To the degree that they'll do that, when they'll do that, it remains to be seen, because the enforcement date has not happened yet. But materially, these are material risks, and you really just need to understand your risk and exposure in those countries, and sort of take your best efforts to try to minimize that, to protect your business.
Yeah, that's great. Thank you, John. Very, very helpful. Let me just have a look at the Q&A panel there, 2 seconds. There's a very good question in here, but I think there's a chance this might have to come as a follow-up, which we're happy to address. And thank you for whoever posted the question, which is, are there any examples of IR websites that are already likely EAA compliant? We can certainly follow up on that point after the webinar is completed. But I think maybe just to comment around general direction, and really how you would think about understanding your own sense of compliance. I think there are obviously things that third parties can help you with, but I think a really good solid first step is to speak with colleagues internally, those who manage your website, those that are responsible for the legal requirements of your firm. Those are really good ports of call initially to try and understand your own compliance in the context of the broader market. That's what I would say to that point, but we will also follow up on that. John, was there anything you wanted to add on that piece?
Yeah, I would say the organizations like Q4, where we have worked over time for other markets like the US market to focus on the standards like the WCAG, that is going to get you a head start compared. So basically, the European Accessibility Act requirements, the presumptive standard I mentioned, is basically WCAG plus a few additional requirements. And so working with organizations that already have experience with the WCAG standards, who have been working in other markets around accessibility, will get you a lot of the way there. And then organizations that are partnered with third-party experts like Level Access will have those resources. Sometimes when you talk to an organization and they say they'll create something that's accessible, they really don't have the experience to back it up. They don't have the testers with disabilities. They're not doing the assistive technology testing that we can do. And so you may not get accessible output. So it's really important to make sure you're working with a partner who can really do those things to make sure you truly are conforming to the standards.
Wonderful. Thanks, John. And just checking through the Q&A panel, I think that's all we had from a Q&A standpoint. So with that, I'd like to say thank you to everyone who joined us today. John, a thank you to you also for your thoughts and comments. Really, really helpful indeed. We will follow up with key resources from the webinar, and you'll also receive today's recording if you want to watch that on demand at a later date. Some further guidance on accessibility, as well as contact information for Q4 and John and his team at Level Access in case you have more questions or want to continue the conversation. So thanks again, all of you, for joining, and have a good rest of your morning or afternoon, wherever you're based.
Thank you. Bye.
Bye-bye.